We want to, I think we have to probably get going and Bob shows up. So let's call the Lake Auburn Watershed Protection Commission meeting of June 9th to order. I think our first order of business is minutes of April 14th, 2021. I have a motion.
Make a motion to approve the minutes of the regular meeting of April 14th, 2021.
Do I have a second?
I'll second.
Any discussion? Comments or changes? Okay. All in favor? I won't come next time, Mary Ann. That's okay. No, please do. Actually, you can be Alicia's not here. Yeah. The second item is our quarterly report. Heather's out today, and due to other activities, she wasn't able to pull a report together. So since my understanding, we don't have a report today, financial report. Is that true? Correct. So we'll move on and take that up in 2 months, if that's okay. Item number 3 is Jim is going to kind of go through our roles and authorities and where we draw those from, and I'll turn over to Jim.
Thank you very much. It's my pleasure to be here. My name is Jim Cross. I work at Skelton Taylor & Abbott as an attorney there and shareholder, and I'm happy to represent the Lake Auburn Watershed Protection Commission. It's been really good pleasure of mine to kind of work through some of these issues as they come up over the last few years, and understanding, I think, as commissioners, where the authority of the Lake Auburn Watershed Protection Commission comes from, and sort of the interplay that it has with some of the other organizations that are involved in its formation is important. Sid asked me to take this on and to give you guys just some guidelines and some information, and hopefully it's helpful for you as I'm going through this. Feel free to ask any questions. I do understand you guys have a pretty full agenda today, so I don't want to take up too much time, but at the same time, this is worth going through. I'll start by saying you owe a thanks to the staff who put together, through some pretty good effort, a nice orientation booklet for you that contains a whole lot of useful material, and I'll reference a couple of pages in there through some of the sources that I'll discuss. But I do suggest that if you have questions that you don't feel are answered today, or as you're doing your official duties as a commissioner and questions come up, that's going to be a great resource for you going forward. I guess just starting out, it's important to understand the power hierarchy that's at play with Lake Auburn Watershed Protection Commission, and this slide is just intended to illustrate that. LAWPC authority is derived from the Interlocal agreement that created it in 1993. And all authority of the parties to the interlocal agreement is derived from the state of Maine. So you sort of have these layers. The state of Maine is vested with powers and authority that is granted to it by the United States Constitution. One organization cannot exercise power that wasn't granted to it by the superior entity. And so we're sort of at the bottom, lowest totem pole here. And the interlocal agreement really defines what powers and authorities the city of Lewiston, the town of Turner, and the Auburn Water District have granted to the Water Protection Commission. Simple example is that the state of Maine couldn't declare an act of war against another country because that power is invested to it by the United States Constitution. I think a good place to start in understanding what LAWPC does is to understand what the Water District does. The Auburn Water District was created by a private and special law of the state legislature, as opposed to a public law. Private and special law is a grant of very specific authority to either create a new corporation, a new political subdivision, and sometimes to exercise other corporate purposes that can be granted by state government. And in 1923, such a private and special law was adopted. And Section 1 of the Charter outlines some really important information here. It describes the purpose of the Water District, which is to supply the inhabitants of the district with pure water, we'll come back to that term, for domestic, sanitary, and municipal purposes. And then here's the big one: all incidental rights, powers, and privileges necessary to accomplish that objective. Similar to the necessary and proper clause of the United States Constitution, you've sort of got this legally binding language here that grants pretty broad authority to the Auburn Water District to effect its purpose. Getting a little bit deeper into the authority and power of the water district, turning to section 6 of the Auburn Water District Charter, that private and special law that I was referring to, the water district has the power to adopt laws not inconsistent with the general laws of the state of Maine, to prevent the pollution of the water of Lake Auburn and preserve the purity of the water. And it says in the underlying language of the charter, which said bylaws shall have the same force and effect as municipal ordinances. And as a necessary and proper extension of that authority to create bylaws having the effect of municipal ordinances, the water district also has the power to enforce those bylaws by going into court and enjoining, preventing, restraining any person from polluting the water of Lake Auburn. And that is really sort of a powerful set of authorities to have as an entity. And as I say, it's a broad grant of authority. Understand that the term bylaw is an old term that was used to mean what we think of today as ordinances, locally created laws, something below the level of a state statute that has the weight of law within that municipal jurisdiction. So the word bylaw is used throughout here interchangeably with the word ordinance in this presentation. Getting to the question of what is pure water, I guess, as probably you're getting before already know, the Safe Drinking Water Act, federal legislation requires that disinfection would be mandatory for providers of public water that use surface water, and in some cases filtration is required. With regard to filtration systems, the Act requires the Environmental Protection Agency to prescribe criteria outlining public water systems, what their obligations are for filtration. Federal regulations direct that what the specific criteria is, put a little more meat on the bone, which is a concept we'll come back to, put a little meat on the bone for the Safe Drinking Water Act, and then that authority of the EPA is delegated to the state of Maine. So in the context of the Auburn Water Districts and the city of Lewiston's securing a waiver from those filtration requirements that were being imposed or could have been imposed on them by the state by virtue of the power granted to them by the federal government under the Safe Drinking Water Act, the parties got together with the town of Turner to create Lake Auburn Watershed Protection Commission through this interlocal cooperation agreement dated June 29, 1993, one of the first documents in your orientation binder. The formation of this entity was a precondition for approval of that waiver from the filtration requirement, one of many preconditions that were required to secure that filtration waiver. And it's interesting because a lot of the language that is contained in the interlocal agreement as to the powers and limitations on authority come directly from state statute Title 30A, Chapter 115, which governs interlocal cooperation agreements and provides the framework for municipalities, quasi-municipal organizations to get together and say, hey, wait, can we achieve a common purpose? And there are many different requirements for those joint cooperative agreements, interlocal cooperative agreements to be effective and comply with state statute. And we see some evidence of that contained within the 1993 interlocal agreement. Specifically, limitations in interlocal agreement that are specified in state statute are that any new entity arising out of or an association arising out of an interlocal cooperative agreement cannot have the authority to legislate, the authority of eminent domain, or the taxing powers of a municipality. So that's one distinction here that the legislature put on these types of interlocal associations, commissions, entities to perform mutually beneficial purposes. And as I said, that is reflected in the interlocal agreement. One thing, I guess a couple other things to point out here. Under the state statute, if a party fails to perform their obligations or conducts themselves in a way that causes damage to another party to an interlocal agreement. So let's say, for example, that the Auburn Water District did something that was an abrogation of the interlocal agreement in some way, or the city of Lewiston did something that was a direct violation of the terms of the interlocal agreement that gives rise to this organization, that party could be liable to the town of Turner or the city of Lewiston, or they could be liable to the other parties to the agreement. So there is this sort of inherent good faith that has to exist between the parties to this interlocal cooperation agreement that is essentially the same as what you would find as an obligation to being a party to a contract. You have an obligation to act in good faith to the person on the other side of any contract. So really, this is really grounded in those contract principles of law. I'll just point out, I do think it's interesting, and others have noted the same to me, that the city of Auburn is not a party to the interlocal agreement. Obviously, with the lake being located in Auburn, that might be a logical conclusion in the minds of some. But it was not a party to this, and the Auburn Water District, it is really the other major player here under your interlocal agreement in conjunction with the city of Lewiston. Not to say that the town of Turner or the other towns that are represented don't have anything to say or anything to lose, but when you look at who really the parties are to the agreement and what the obligations are of those parties to act in good faith, those are the three entities that we're talking about. There's a nice section in the interlocal agreement that talks about Lake Auburn Watershed Protection Commission purposes. These are outlined here, and I won't read through all of them, but one thing that is interesting to note is that maintaining the waiver for the filtration requirement is not specified in the agreement in that section as to the purposes of the organization. But you will find references to the filtration, preserving the filtration and the waiver to the filtration requirement throughout the document, and we'll look at a couple of those as we go through this. But I do think it is safe to say that part of the purpose of Lake Auburn Watershed Protection Commission is to maintain that waiver. Acting on behalf of the parties to the agreement to implement ordinances, rules, regulations, programs, and policies. And I think that's an important word. And it goes hand in hand with the limitation on the power of this organization to legislate. As the implementer of the bylaws of the Auburn Water District and other state laws that pertain to land use that the Commission has the authority to enforce here, you're not creating those laws, and there are limitations on your ability to legislate that I think are important to recognize. The organization has done a really good job over the years of promulgating and adopting policies, rules, regulations, we might call them. But they're specifically putting meat on the bone, as you might say. It's the Auburn Water District, the state of Maine, in certain instances, the city of Auburn, following the lead of the Water District in some of their zoning regulations that are really legislating, putting the big brushstrokes on what you can and can't do, for example. And then it's up to the LAWPC to put the meat on the bone to define really how that's going to work in different areas of the watershed, for example. But really defining sort of those broader brushstrokes of what's possible and what's not.
Councilor, question?
Yes.
In implementing, can LAWPC implement ordinances and rules and regulations for the other municipalities that are within our watershed? Like, for instance, can we go and start a process with this committee to ask Turner to limit certain types of building, uses, certain types of logging uses?
I think you need to have a source from which you would derive that authority. So, for example,
In Turner's ordinance, or state ordinance.
Exactly. Or yes, or if there, I think there's a small portion of the watershed overlay district that might extend into Turner, a small portion. So if the Auburn Water District were to say, for example, within the watershed that overlay those boundaries, you can no longer fish, for example, in any of those tributaries. I think that that would have weight and effect in the town of Turner. And I think that the Lake Auburn Watershed Protection Commission would have the ability to figure out how to make that work. How do you implement that bylaw, that regulation? the water district's authority extends to not only the waters of Lake Auburn, but its tributaries. And so it's an interesting question.
Future agenda item,
And
please.
it gets, but it does, and I hope that as we go through the presentation that you'll think of some of those questions and maybe figure out how the pieces fit together. Reviewing land uses within the watershed could mean reviewing land uses that the town of Turner is implementing within the watershed. And then maybe you don't like what the town of Turner might be doing within the watershed. The Lake Auburn Watershed Protection Commission could make a recommendation to the Auburn Water District and say, hey, we think that this might be a problem. We would make a recommendation that you adopt a bylaw, for example, an ordinance that would have this effect. So we'll get into a little bit about that as we get into powers.
Well, that'll be popular. I know.
Going to the next slide. Oh, I don't want to gloss over this. Holding title to land is one of the powers, one of the purposes, and specific authorities granted. That's really important. A lot comes with that. There's a lot of rights tangled up in that, and importantly, to prosecute and resolve legal action to enforce drinking water protection laws and regulations. And I want to note that that's concurrent authority with the Auburn Water District within the totality of the watershed. So the interlocal agreement is pretty specific on that there is this shared authority between the district and the Water Protection Commission to take legal action to enforce those regulations and ordinances. Looking at some of the powers, moving on from purposes and going to powers, of course there's a little bit of overlap in some of these things, and it depends on whether something's a power or a purpose, is just more or less how you look at it to a certain extent. But there's a couple of things in here that are, I think, really important to understand. And it gets to, if you looked at page 12, 11 sub I, under powers within the interlocal agreement, you would see that it's the authority to act on behalf of the parties to implement those ordinances, rules. Again, it's going back and falling back to implementing, which means to carry out and administer or fulfill the requirements of the lawful bylaws, ordinances of the Auburn Water District. We just touched on the concurrent authority there for enforcement. If you think about how federal government is set up and the roles that federal agencies play, federal agencies lie within the executive branch of government. And they're there to ensure that the laws of Congress are implemented and enforced. Whether it's a police agency that's enforcing a criminal law, or the Social Security Administration that's enforcing, acting out, implementing, and carrying out its purposes under federal statute. So I think it's helpful to think about LAWPC as being that enforcement arm that you might think of in the executive branch of federal government. If you went to, if you want to look at what some of the specific charges are that the commission is charged with enforcing, you could turn to page 23 of your handbook or to page 39 of your handbook, and you'll find examples. You'll find the bylaws for the protection of Lake Auburn, adopted by the legislating authority of the Auburn Water District. It's similar, and you'll see that the definition of the watershed overlay district and the shoreland overlay district are also in there. So those are the types of things that we're talking about as forming the basis, the legislation that the commission is working from and implementing and enforcing. Once again, entering into contracts, applying for grants, those seem like, why do you need to specify that? But you do, because you only have the power and authority delegated to you in the interlocal agreement, okay? And anything that might be reasonably necessary in furtherance of those purposes and powers. So having these specific grants is an important and not insignificant thing to note. I thought it was interesting to see that there is this ability to define watershed boundaries in the interlocal agreement, because I believe the water district also has that authority. So, I don't know if that was an oversight or if they really intended it to be concurrent authority, but that would be an interesting dispute that I don't imagine will ever arise, but it is interesting. Limitations on authority are almost as important as understanding what authorities the organization actually does have. And I touched a little bit on this earlier in the presentation, talking about some of those limitations of Chapter 115 as they relate to taxing, eminent domain, and legislation. And I think that under Section 7, there's a couple of sections that we're going to talk about in the next few slides. It's a really good section to get into because it's titled, Section 7 is titled Limitations, which tells us something from the heading. But it's interesting because the district, the Auburn Water District, reserved unto itself the sole and exclusive right to exercise its own legal powers, responsibilities, and prerogatives, and to be the one that enacts those bylaws, those ordinances. So I can imagine the tension in 1992 leading up to the execution of the interlocal agreement when the water district maybe was saying, no, wait, why are we going to give, we'll be happy to give the Lake Auburn Watershed Protection Commission some authority, but we want to make it really clear that they're not coming in here and taking away our power to adopt bylaws that have the weight of ordinance. That's our responsibility by charter, and we're not ceding that to the Water Protection Commission. So, you know, you've got some of those limitations on there that not only follow the Chapter 115 state law limitations on interlocal cooperation agreements, but I think that we're also the product of some negotiation between the parties that created this organization. I talked about regulation and rule versus statute and ordinance, so I think we're all set there, but if we wanted to look at some examples in your orientation handbook of what we might call rules or regulations that the Watershed Protection Commission has adopted to put meat on the bones, we've got the LAWPC forestry policy. I see that there's a draft going of the land management plan. You've got a water hauler policy that's been adopted. And those policies, whether it's a forest policy, forestry policy, land management plan, those really are putting the specifics and putting the meat on the bones around the existing protections that are established by the bylaws that have been adopted by the Water District. And to a certain extent, the city of Auburn has, you know, they've got their definition of the overlay that is the same as what the district says. But those are just some examples there. So I see that you guys are working on this draft and the draft land management plan, and it might be good to take a look at that with a critical eye and say, wait, are we doing more than we really have the authority to do? What's our authority for putting this provision in there? Can we fall back on something that's in one of the bylaws of the water district? Always going back to that and realizing you can't do more than you're authorized to do.
Another quick question, Jim.
Yeah.
Regarding implementing changes, is back to pure water, is it the Auburn Water District's responsibility to address, for instance, the difference between surface water rules and ice? What's going on top of the ice? Because some state definitions are like, well, it's kind of like a layer. Like you're for instance, we had 3 years ago, I think Erica called out a ski plane that had landed on Lake Auburn. Because seaplanes are prohibited, I think you just assumed maybe all planes were prohibited. So we didn't know, and someone had mentioned, well, the rules and regulations that the state, the power is given to the Auburn Water District are only pertaining to water rules, not rules of ice. Another good example is, historically, snowmobiles have the permission to traverse the ice, even through what the former watershed coordinator, through the restricted area. She had said, no, you can't do that, but there's never been a rule that a snowmobile can't, and they've always done that since the 70s. They've gone from one end of the lake to the other lake. So, and this could just be a future agenda item as well, is who should be looking at, is it the water district? Because it's a bylaw, I guess, that you can't have seaplanes. So how do we address surface water versus surface ice?
Well, I think, you're asking a hypothetical question, so, I'm going to give you my off-the-cuff answer.
Right.
But I do believe that the Auburn Water District has very broad authority under its charter that it derives from the state of Maine to regulate Lake Auburn and what happens on Lake Auburn, whether it's frozen or not.
Okay.
In order to protect the pollution of Lake Auburn from pollution or any detrimental effects that would degrade the purity of the water. So I think that the district's charter itself grants it broad authority not only to regulate the surface water when it's in liquid form, but also when it's in frozen form.
So that would be an Auburn Water District agenda item to figure out and update the bylaws. I think we're scheduled to do that after the city study comes out.
Yeah, I mean, there's also the potential that the argument can be made that based on the existing bylaws, that the authority exists for the commission to draw from those existing bylaws. And you're not really creating a new piece of legislation. You're saying, because of this bylaw, here's what you can do in the summer, here's what you can do in the
Is
winter.
that somewhat analogous to the state government, the difference between state statute and agency rule?
Exactly.
Because an agency is really the implementing arm of the executive branch, and the rules are, you can't be counter to, you can't go beyond, but within the scope of, you're redefining how you're gonna implement, and is that similar analogy?
It is very, very similar, and I think that's definitely one thing that we need to, that is helpful for understanding this role. You're putting the meat on the bones. That's what a state agency does. That's what a federal agency does. Congress intentionally, and I'm assuming the state as well, but there's examples in Congress that come to mind. They'll write a statute in sort of broader terms, so that they don't have to take the hard political bites and really put a lot of definition. And then once the law passes, it gets kicked to the agency to put the meat on the bones and do all the things that
A lot of federal and state environmental laws like that. And even in the last, oftentimes in the last item, it actually instructs the agency to do so, right? Sometimes it does, sometimes it doesn't, but many times it actually instructs the agency.
And if you look at the interlocal agreement that gave rise to this organization, you'll see that it discusses having to provide notice to the public before you have a process that you go
Sounds
through.
like rulemaking.
Sounds exactly like rulemaking, doesn't it? So it would be interesting to see, I suspect that if a court were to examine, if somebody were to challenge the forestry policy, for example, that the commission has, that a court would look at that sort of with the same standard that it would apply to a state agency. It is very analogous. You're the enforcement and implementation arm, and you're the one putting the meat on the bones. And as we see in court cases involving challenges to state agency rules, 95% of the time, the court is going to defer to the knowledge that the agency has of the subject matter that they are regulating and charged with regulating by Congress. So,
In my state service for a number of years, 22 years, most agency rules that have been overturned that I know of are less on that and more on the process and the public process and following the Administrative Procedures Act to get there, right?
You're exactly right.
Yeah, that's usually what causes
Right, because if it gets down to an argument that the substance goes beyond what the state legislature intended, it goes beyond, those are really hard arguments to make.
But not following the process or somewhat
But
easier.
not following the process can be pretty black and
The
white,
public
easier to
process.
prove. So as you move forward with your draft plan that you're working on, that's contained within your booklet, keep that in mind, that you do have this process that you have to go through in order for those to be officially adopted.
How would you suggest moving forward as we review the bylaws for the protection of Lake Auburn? What role would you suggest this entity has to weigh in on any changes that might take place in that?
You're talking about the Auburn Water District bylaws for the protection of Lake Auburn?
Right.
Yep, those carry the weight of ordinance, and that's a very timely question, Sid, because that's what this slide is about,
Okay, great.
okay?
Nice segue, Sid.
Yeah, this slide is about section 7, and I think it's really interesting, and maybe that's because I'm a geek about these sort of things, but it's under limitations, but as I read it, it also seems to give the Lake Auburn Watershed Protection Commission an ability to compel the water district to legislate in a certain way.
That's odd.
Right? So you don't have the ability to legislate, but if you read this language here in that second bullet, The Auburn Water District pledges, covenants, and agrees to consider recommendations from the commission and also to exercise its regulatory authority, blah, 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 not relevant, and to enact, amend, and repeal those lawful bylaws, regulations, orders, or ordinances in such a manner and to such extent as is required or advisable to control and protect the watershed or waters of Lake Auburn in order for them to maintain their exemption from the filtration requirement. So, I guess first thing to point out real quickly is that the filtration requirement is listed there as something that's recognizable. It finds its way into this agreement over and over again. So we can see that that's sort of a shared value of the members, the parties to this agreement. But there really is a role here. Let me go to the next slide because there's a couple of examples that I tried to cite to. If the Lake Auburn Watershed Protection Commission wanted to make a recommendation that the Auburn Water District make some changes to its bylaws, and it brought forth those recommendations together with an agreement to indemnify the Auburn Water District from anything that might happen as a result, then arguably, I would argue that this language in that second bullet in section 7 requires the Auburn Water District to enact, amend, or repeal the bylaws, those lawful ordinances, if they were satisfied that it was in furtherance of the purpose of protecting the waters of Lake Auburn and in furtherance of the purpose to maintain the exemption from filtration. So, you know, let's say that that this organization wanted to make it unlawful to have those camps that are on the spring road. There's a bunch of non-conforming, pre-existing, grandfathered uses that would not be allowed to be built today. And let's say the commission said, we need to get rid of those, they're causing a lot of problems to the water of Lake Auburn. There's like, what, 3 of them or 2 of them? If you made a recommendation and signed an indemnification agreement for the water district to get rid of those uses, well, what would happen? Okay, the water district could adopt a bylaw. They might arguably be compelled to do that because it is for the benefit of the water if those properties aren't there. But what does it do? It infringes on the property rights of the people that own those homes, that own those properties. So what would happen is the owners of those properties would turn around and sue the water district and say, you can't take this away from us. This is, if you're gonna stop us from having these camps, you have to do it by eminent domain. Otherwise, this is an unlawful ordinance that you've adopted. And then the Auburn Water District would say, well, we have to go to court on this, but Watershed Protection Commission, this was your recommendation. We adopted it pursuant to the interlocal agreement because we have to act in good faith, right? We have to act in good faith toward the parties. And so you're going to be on the hook for the cost of all this litigation. And if it's a judge that we were wrong in doing that and in taking those properties in the way we went about doing it, then you've got to pay those damages. So yes, you have the authority to, your authority is to make recommendations to the Auburn Water District to amend its bylaws, repeal bylaws, enact new ones, so long as they're for the protection of the waiver from filtration and the protection of the water. And this organization signs an indemnity agreement and agrees to indemnify the water district for any costs associated with them moving forward with the recommendation. Then I think the Auburn Water District is compelled at that point to act in furtherance of the recommendation. And it's interesting because it goes back to sort of that being liable for one party's acts. Okay, if one party acts in contravention of the interlocal agreement, then they could be liable for that. So if the Auburn Water District were to say, no, we're not enacting that, there's no way we're doing that, they would be acting in contradiction to the purposes that this commission and its members have determined was in the best interest of protecting the watershed. So I think that the indemnification provision there is a way to address what might be perceived to be a lack of good faith on the part of the Auburn Water District if they were to refuse to make the recommended changes. And it gives them the cover that they would need and say, okay, we'll do this. We might not agree, but if this is your recommendation on its face, it seems to protect the waters of Lake Auburn, and that's its intent. It doesn't jeopardize the filtration waiver. You signed an indemnity, we'll make the change.
So I think you just answered that, but a recommendation issued from this commission to Auburn Water District wouldn't necessarily infer indemnification. It would actually be have to be explicit, right?
Yes.
So we could make a series of recommendations for them to select and choose. If they chose it, then that doesn't infer an indemnification unless it's specific. There was a specific expression in the agreement.
You can make a recommendation to the Auburn Water District and say, hey, this is our recommendation, please consider it. If there's no indemnification,
It's not applied.
it doesn't compel them to act. Okay? If there was a change that you really felt strongly about and just felt absolutely had to be implemented, if you sign that indemnification agreement, I think that the district would be in a position of having to move forward with adopting that.
If it truly forwards the
As long as, the out that they could have, as I would read this, the one out that they could have is that that's not in furtherance of maintaining the filtration. That could actually cause damage to the purity of the waters of Lake Auburn if we were to make that change. So you couldn't say, we are going to, we're recommending that you redefine the boundaries of the watershed so that it only encompasses the first 200 feet of shoreline around the lake. Right? Because even if you agree to indemnify them for the results that might follow from that, that on its face doesn't do any, it jeopardizes. It jeopardizes the purity.
On a practical level, the water district is, it's right in the bylaws to review it every 5 years. It has not been reviewed for quite a while.
15 or something like that.
Yeah, so moving ahead on a practical level, would you recommend this body review the bylaws and come back with recommendations to the water district? I mean, this is the chance for this body to weigh in on anything. They might look at it and say, everything looks great. Our recommendation is to leave it alone. That might be I don't know what the recommendation could be, but that might be what comes out of it.
Well, I think for just looking at it from a purely efficiency purpose, it doesn't make sense for the water district to endeavor in a months-long process of review and making recommended changes, and then the watershed protection district weighs in later and says, not that the water district wouldn't have the authority to do that and make those changes without consulting with the commission, but the commission could then say, well, you did X, Y, and Z, we disagree completely, we make a recommendation and here's our indemnification, that you change it back to this. That incorporates the city of Lewiston's perspective, everybody who's sitting here from different communities.
So it makes sense for this board to weigh in first, and then...
Just from a purely efficiency
I
perspective.
think efficiency and I think implementation, right? Again, this is the agency that's going to implement some of those, right? And if this agency doesn't feel it can or could or has the resources or for whatever reason, it would be nice to have that before you have a bylaw that is an ineffective bylaw because the agency can't carry that action out.
So just a quick few words in the benefit of some of the commissioners that haven't been here that long. I've been involved maybe 15, 18 years. It's the City of Auburn City Councilors that put the Auburn Water District trustees in place. And then the Auburn Water District trustees put 3 of the commissioners, one can be dual role like myself. So in the past, I would suggest this board move forward knowing that the demographics, in case you can attest to this, to the Auburn Water District Board right now has changed significantly to support City of Auburn issues. And I think that's why the city has done its own study to see what we can and can't do with this very valuable resource, not only drinking water, but as a great pond in the state of Maine for recreation. So you have to remember that too, that it's just going to be more commissioners that are going to be like total pro in it. And how far do we get before we've already seen it? Before Auburn is against Lewiston with Lake Auburn, because Auburn is basically looking at Lewiston paying 65% of all the costs for the lake because they use 65% of the water. Now, that would have never happened had we had an Auburn Water District that, was of 15, 20 years ago. So you have to think too, we have to think going forward that the district has changed because of some issues in the past.
Well, the membership of this organization is specifically defined in the interlocal agreement. And this organization exists for that implementation and an acting purpose, and it doesn't have legislative authority. Okay, except for this one narrow section.
Used to have
where
the ability to compel something.
maybe have the ability to compel the water district to do some things. But, this organization exists because the parties are working together in good faith toward a common purpose.
That has to continue.
And that has to continue. To the extent that erodes, then there could be a fundamental breakdown where, and I get to that a little bit later on in terms of termination and other things that could happen, breach of one party's obligation to another.
And this interlocal agreement spelled out that all costs would be shared equally. I mean, it's right in this agreement.
Costs for funding the budget for this organization.
So locked right into the interlocal agreement.
We got that. So, this is moving along sort of logically because I think you just referenced it, Dale, is that the Auburn Water District has the ability to affect the Lake Auburn Watershed Protection Commission. This is sort of the example where we're talking about where what if the water district makes changes to the bylaws, right, that the commission doesn't approve of necessarily. Well, there's an example here. If Congress changed federal law to eliminate Social Security disability programs, they said, okay, all disability insurance is private. We're not going to have a federally subsidized disability program anymore. Now the Social Security Administration loses essentially half of its functions. All it's going to do now is administer, the railroad worker thing that they deal with, and then old age retirement benefits would be its sole purpose. And that's very similar to the Water District's authority to affect the scope and power of Lake Auburn Watershed Protection Commission. They have the right to adopt bylaws to govern the surface waters of Lake Auburn. And what they issue as bylaws has the weight of law. And you guys are here to implement those laws. So if they got rid of half of them, you might disagree with it. You might end up going down this road of making recommendations and having a fight, and maybe things break down at that point. But, at this point, the water district has a very real ability to affect what you guys do by either expanding your reach and authority by, it's a bad example because it's based on geography and all those other things, topography and everything else, but expanding the size of the watershed by definition through a bylaw would have an effect on how many employees you need to monitor, all of these easements and all this whole area of the watershed. So the water district has a real ability to affect what this organization does by virtue of those ordinances that it adopts. We see this a lot in interlocal agreements. One of the statutory requirements of an interlocal cooperative agreement in Chapter 15 of Title 30A is that it has to be of a definite duration, or it has to be of a specific duration. And I always thought that meant it had to be for a defined duration. But probably 90% of every interlocal agreement I've ever looked at is of an indefinite duration unless it's terminated or something else happens to cause it to come to an end. And that's how the interlocal agreement is drafted. It's of indefinite duration. Either party can terminate the agreement due to a material breach by the other that's not cured in 90 days. So if the Auburn Water District thought that Lewiston was doing something that was a material breach of the interlocal agreement, it would send a notice to the city of Lewiston, probably to its water division, and copy to the manager and say, hey, this is what you're doing here violates the interlocal agreement. Maybe they stop paying half of their share of the budget. It's spelled out right there in the agreement. If they just didn't send the money that they're supposed to, that's clear breach. They've got 90 days to tender the funds. And if they don't, then upon that written notice, the agreement terminates. And of course, the Department of Human Services is involved in this, so they'd have to get a copy of it as well to be effective. Can be terminated by mutual agreement, essentially, by vote of the Lewiston City Council and also the Auburn Water District trustees. So those two mechanisms for termination are spelled out in your interlocal agreement.
You just mentioned human services, Sue. Was it, I don't know if that was on a previous slide, but aren't any revisions to this document need to be reviewed? Yeah.
Yeah.
It says there, it does need to go through DHS, any changes. This is termination, but, okay, there you go. So it's going to go to the DHS. Any amendment to this must be agreed to.
Has to be approved. Have to be approved by the Department of Human Services.
Right.
So if you wanted to make changes to the interlocal agreement, the parties can agree to do that and enter into an amendment, and then you've got to ship it off to the state and get the state's approval on the amendment.
Right.
So that's the main drinking water program that's part of DHS,
Yes,
right?
correct.
Yeah.
Right.
So what happens if a party ceases to exist? Well, like, I don't know, like, let's say something crazy happens and Lewiston becomes part of Sabatis and Lewiston no longer exists. Well,
Right.
like, that's not gonna happen, but.
I guess that's an interesting question, but I think that if Lewiston ceased to exist, it would be probably more likely that Sabatis would cease to exist and be absorbed by Lewiston.
Right, but I'm saying, well, I guess I went the crazy one, but it wouldn't necessarily be out of the realm of possibility that the Auburn Water District, for instance,
So-
would always exist.
If, let's say that there was a merger between Lewiston and Auburn, because that's not so crazy, right?
Right.
Unfortunately, it is, but it might not be unwise, but it is, yes.
It's not crazy to suggest.
It's not
let me say
unwise, no.
that.
It might not be
Been
unwise.
there, done that.
Haven't tried that.
If that were to happen, I could, I guess I don't know what would happen. I mean, the agreement couldn't be affected, right? Because you would have to at least have an amendment to it to keep it alive. Because the city of Lewiston could no longer send their 50% of the funding for this organization. So there would have to be other instruments in place. I suppose that you could make an argument that impossibility, that this whole agreement is terminated by frustration of purpose and impossibility.
Jim, you may cover it later. I'm sorry, I can't go on. If there were a termination of the agreement, there are assets, and I remember last time we kind of went through with you a little bit about what the procedure would be and what the distribution or disposition of those assets would be.
So, and this is reflected in the agreement. There's a specific section that addresses this, and it's basically mirrors state law. Okay, and state law says that any property acquired after formation.
Oh, sorry.
That's okay. We didn't cover it. I wasn't
I
asked it.
didn't read that.
We got to the amendment question before we got to that. But yeah, any property acquired by the organization after its formation is then held as tenants in common with an undivided equal interest. So both parties have a 50-50 ownership interest in the brick building that they built, the truck that they bought together, the real estate that they acquired, the rights in easements that they acquired.
Like a marriage.
That's why I'm mad.
Yeah, exactly. But any property that was brought into the relationship, like a marriage, any of your premarital property, is distributed to the party that owned it prior to June 29, 1993.
I missed that. That was what I was driving at. I missed that part the first time we had that conversation. I had actually thought all property that came in, the Auburn Water District owned a number of pieces of property, and those came into the agreement and now are under the stewardship of the commission. I thought those ended up in a 50-50 split too. So I misunderstood that.
So,
Well, everything wasn't, all Auburn's property was,
Right. I think Jim's saying, when you and I have a divorce, you get to keep the stuff you had before.
yeah,
I thought, and I misunderstood, I thought it was all properties became property in common.
but let's make sure we're,
well, they are in common now.
But if we split, when you and I have a divorce.
well, let's make sure we're
I
talking,
forget my alimony.
let's make sure we're talking about the same thing. We're talking about property owned by the commission.
But wasn't there property, this is maybe where I might have been my misunderstanding, there was property, real estate property owned by, and others probably, but there was real estate lease property owned by Auburn Water District prior to formation of the commission. If the commission were to dissolve, what I thought I heard you say before, and I just probably misunderstood it, that that property would be in common 50-50, but it sounds like that actually reverts back to.
Yeah. If you brought it into the relationship,
And take it on the other end.
the interlocal
Is that
agreement.
working like it was?
The interlocal agreement requires that the parties convey the property that they're bringing into the agreement to the Lake Auburn Watershed Protection Commission. So, upon termination, it goes back to the party that brought it into the relationship, and any property acquired during the relationship is 50-50.
Gotcha, that helps, I missed that point.
We covered amendment. I guess, from here we get into duties of commissioners and then a couple of FOA things that I want to touch on, or how are we doing on time, Sid?
Up to Dale, Commission.
I think we're okay.
Okay.
We got a page or two left, right?
Yep, and I'll try to be quick. I think that this,
We'll make six real quick.
this next slide on duties of commissioners, I think it's kind of important to go over. Fortunately, you have a standard of conduct for LAWPC that's at page 115 of the handbook that was distributed. At some point that got adopted by the commission, so you can make reference to that. One of the things that it covers that can sometimes get tricky, and nobody ever intends for it to be that way, but you need to remember that commissioners don't have any authority to act independently on behalf of the body. And you might not have the intent of acting on behalf of the commission if you're in conversation with somebody in another setting, but they need to be really clear that maybe what you're saying isn't reflective and you don't have the authority to bind the Lake Auburn Watershed Protection Commission to anything that you might be offering. There's a concept called apparent authority, which is that if a person has reason to believe that you have the authority to act on behalf of another, that person who has that apparent authority can actually bind the entity, right? So the actual authority, no, you don't have that. But if you have apparent authority, which as commissioners, arguably you're in a situation where you could end up binding the commission to something, and that would be a violation of your ethical duties, and you'd be violating your duty to faithfully discharge your duties in service of this organization. And that can just come up in a lot of settings. One thing that I thought of is speaking at like a city council meeting. If you're there as a citizen advocating something that you believe in, that's fine. But if you're going to go to a city council meeting and start talking about things that fall within the purview of this organization, you need to be very, very careful about that. And it needs to be extremely clear to your audience that you're not representing the commission when you're making these statements, okay? Because you don't want to suggest that you're representing the will of this collective body. You act together based on the votes that are taken of the quorum that's present on that particular day. You can't use the organization for your own private gain, and that extends to your title as well. So you can't, it would be unethical and a violation of your duty to faithfully discharge your obligations to the organization if you were to use your title as a commissioner to try to gain favor from somebody in a land deal, maybe suggesting that you have the ability to effectuate something just because you're a commissioner. That's all. It can be easy to cross those lines without realizing you're doing it. The way I've said it right there is it's kind of clear, and you'd be like, yeah, I would never do that. But people might be talking to you because they know you're a commissioner, right? And they might be approaching you about a subject because of your specific role. So you just want to be cautious about that. And it's very explicit, don't violate any of the lawful orders of the commission, and no conflicts of interest. We kind of just basically touched on that.
Does this also apply to staff?
Yes.
Okay.
Yeah, it
So
does.
duties of the commissioners and staff?
Yeah, the standard of conduct, I think, is specific that it's to staff and also to the commissioners. So. I guess, I just want to touch on these things because they come up in my life all the time. FOA issues, open government laws. This organization is subject to open government laws. These are public proceedings, as you know. FOA, Freedom of Access Act, people think of that like, oh, you're requesting information, but really it's more than that. It's freedom of access to your government. And there are different ways that, members of organizations that fall under open government laws can get themselves into a little bit of trouble or cause trouble for the organization. Usually this is well-intended behavior that has an unlawful effect. Illegal meetings, a quorum, you've got a pretty big quorum, so it's probably less likely to happen. It's more likely to happen on smaller boards. But you don't want to have an email with a quorum of this organization, or more likely all of you on a group email, where you're deliberating about an issue that has to come before the commission. Okay, it's okay for Erica or Sid to send out an email saying, hey, we've got this meeting coming up, here's what we're going to be talking about. You can get into even details about, will there be this handout, will you hand that out? That's all well and good. But when you venture into actually deliberating or discussing the merits of a particular position on an issue, you really don't want to do those in any setting besides a properly noticed public meeting, because that's where the business of this organization is required to transpire. So.
And I think that's a place we've kind of got on the edge of a few times, where we've wanted to have meetings or field trips, and we just got to be really careful about doing public notice. And these are if we get a quorum together at any place where we're going to have a discussion that might lead to an action in the end. Unfortunately, I'm a FOIA officer too, and it drives me nuts. But we just got to make sure we're posting those. We can't just have these ad hoc.
Yeah, you can't all just meet at parcel 4 and say, hey, let's take a walk, and then you're all there together. That's a public meeting. It has to be noticed if it's a quorum.
Thank you.
That's regardless of whether you're having any action. It's the discussion.
Yeah, it's
Right.
It's the discussion that's happening while you're doing all of that.
That may lead to a future action.
Yeah,
Correct.
I mean, if there's a quorum of the board present all together in one place, unless you are absolutely silent the whole time, it's a public meeting, right?
Over a beer and chatting about the weather, that might be all right.
Yeah, if it's two or three of you and you're getting together over a beer or something, that's fine. And I don't want to suggest it's not. If Evan wants to text with Dan about an issue that's been on his mind about commission business, that's okay. It's when you get to a quorum in that discussion outside of a public notice meeting you have a problem. One other thing that I'll just point out here about FOA is with regard to executive session. At the back of the packet, I gave you the state statutes so you can see them, but executive sessions, they can only happen for certain specific purposes. There's only a few of them that would really come up, I think, in the context of the Water Protection Commission. But when you're making a motion to go into executive session, the law requires you to cite the basis for going into executive session. So if you were going into consultant counsel, you'd say, I move to go in pursuant to Title I, Section 405(6) sub E, to consult with counsel regarding a legal matter. And that covers the basis. You've got a brief description, you've got the site, and then a brief description of what you're going to be discussing. And sometimes constituent citizens complain that there's not enough information. Maybe you made the citation, but you didn't say what you were going to be talking about. There can be a fine line, right? Because you don't want to say, we're going in to talk about selling a piece of parcel to Tom Haynes, who lives on the Haynes Road, for $75,000. I mean, the reason you would go into executive session to discuss something like that is because you wouldn't want to compromise your negotiating position as an organization. So, but just good practice is to make sure you're not only citing, but also providing a brief description of the reason for going in.
I have a question sort of related to not the executive session, but the previous topic. So on the planning board, as a planning board member, something that we have to be careful of is sort of bringing information to the table or seeking out information that, say now, I'm the only one that would know. So we're discussing a piece of property, I go out and I individually discuss this issue with that property owner, learn specific information, but then don't disclose to the board that this happened. And so now this is affecting my decision. And so that's like a no-no kind of deal. How does that relate to business of the commission?
I think that you have to go back to what is your duty as a commissioner to faithfully discharge your obligation, to sit here and deliberate, participate in deliberations on the issues of the day that pertain to the business of this organization. Anything that happens in executive session, I would suggest you could not bring that.
Yeah,
So if there's public information, information that would be known to the general public, and I think that anybody that you're talking to, a landowner, for example, who might be involved with the planning board, they've got to understand that you are speaking with them as a public official. Your duty is to the public, right? And oh, by the way, I'm also on the Auburn Watershed Protection Commission.
Right.
They can't expect to confide in you something, right, that they wouldn't want the public to know.
Well, so I guess my question is, so I've attended a few of the MMA, they do session specifically for planning board members, right? And the MMA lawyers have made it very clear that, like, unless that is disclosed, you've now done something illegal, right?
Unless
so,
what's disclosed?
That, so during the meeting, I have this information and I'm using this information to make a decision, and it's information that's affecting a public decision. So I need to disclose that information to the board.
I think that's correct, because
So I'm saying that I would assume that carries over here as well.
yeah, I don't think that anybody could come to you with confidential information, and that the planning board, anything confidential that you can't bring to the commission is only something that you would be discussing in executive session
Right.
with the planning board.
Well, I don't mean coming from the planning board. I'm saying, I'm using the planning board as the example.
What's
because
that obligation?
That's the context in which I understand that.
Okay.
I'm saying, do we have that same obligation as commissioners?
I think that you have a duty of candor.
Yeah.
Okay. I think you've got a duty to be honest and fair dealing. These are fiduciary duties, typically associated with anybody who's acting in the public interest on the public's behalf. Trustees, whether you're a trustee serving a beneficiary of a trust, you've got these very prescribed fiduciary duties. I don't think that the law necessarily goes quite so far, especially when it comes to issues of liability. You're not liable the same way a fiduciary is, but I think that if you approach public service, especially in a volunteer capacity, in these types of roles, whether it's a planning board or the commission, if you approach it with that same sort of outlook of a fiduciary, you're going to be all set.
And related, I'm going to assume that we're still bound by sort of the laws regarding, forgetting the term for it, essentially it would be like a side discussion. So we're in a meeting, and let's say, I don't know, there's a meeting going on, and so Sid and I are actually discussing the topic at hand through text. And we are sharing information with each other that's not being made public in the meeting. But that as well, again, that would be illegal.
Well, so I think I would go back to the fact that there would be a quorum of you present while you're having that side discussion, right?
Yeah.
And so I think that would have to be public. How do
I
you
think it's also in violation of the open meeting law.
Yeah.
Yeah.
Because that part isn't open to the public.
Right, exactly.
Because of the quorum.
You're not in executive session now.
Yeah, I guess I'm just saying, so we touched on those, on the FOAA thing, but I wanted to ask about the two other things, because actually, in my other role, those are the two biggest things that come up with new members, that we really have to tell them,
Can't do that.
you can't do that, literally put your phone away during the meeting.
Yeah.
If someone sends you a text, don't read it.
We've actually had people on different boards forward because somebody noticed they were texting, and their personal phone was FOIA.
Yeah.
There was business occurring, so
Yeah.
it's subject to the FOIA, even if it's your own personal phone. So
Yeah.
those are good points, Evan. I think one more that worries me is just something that happens a lot. We all go into executive session. We might give Sid some instruction, he can go out and talk about it, but we are obligated not to talk about it. Whatever's in executive session, stays in executive session. It's not something we can go out and chat with people in the public.
Well, and I think you bring up an important point. There's no such thing as a private device when it comes to FOA. If you are,
What you're
if
taking
you
off your
get
belt, right?
right, like once, yeah, if you get requested, and you know, there's like
This
you want
personal
every
notebook
document.
has all kinds of city businesses.
Right.
It's not a personal notebook anymore, right?
Yeah, every document, every discussion you had with regard to something.
You're right.
Yeah, don't use your personal device for business, those business conversations that probably shouldn't be happening during a meeting. There's a lot on FOA, and I wanted to actually suggest, I didn't put the link here, but I guess I should have. There's a frequently asked questions section. If you just type main FOA FAQ, you'll come up with a link from Google that will, it's like probably 12 pages long if you printed it, but it goes through a lot of these types of common issues, common questions. And if you're an elected official or appointed to a quasi-municipal organization like the Water District, you have to certify within 120 days of your appointment or election that you've taken some sort of a class on FOA. And reading that frequently asked questions section, there's a self-certifying thing that you can sign at the end that fulfills the requirement of that law. But I do think it's helpful. If you ever have a FOA question, not sure, that's a great resource. One other thing about executive session, you can't make any decisions in executive session. So you guys might deliberate in there, but you've got to come out of executive session, and there has to be a motion probably.
Stuff easy to slip. I know I do. I want to get to it, right? You know, it's easy to forget to come on.
The other thing that comes up a lot that you need to be careful of is stay on topic in executive session. Don't go into executive session and consult with legal counsel and then end up talking about the land deal that you're going to do and negotiate with Joe Schmo, okay? Tom Haynes.
Come on, go back in for that subject, right? If it's subject.
Yeah. If it's on the agenda, then you can go out, go back in.
If you're dealing with multiple issues that are sort of the same, like say there are 2 land transactions, can you do them both under one executive session?
I don't think there's anything wrong with that.
Yeah.
Okay? It's just,
You
I think
do
you
a
just,
land transaction and a personnel matter.
Right.
You have to come on.
Different purposes.
Different
Right.
line.
and I do think it would be, to do 2 land transactions in one executive session, that it would be one of those occasions when you would want to say, make sure that you say, we're going in pursuant to, and then to discuss 2 potential land transactions.
Okay.
So that the public's aware you're not just talking about one thing, you're talking about multiple things.
Okay.
Jim, on the land transactions, and I brought this up to the commission maybe last year. Is it okay for Sid to be regulating a parcel and then trying to buy that same parcel on behalf of the commission? Because he's regulating the parcel as an Auburn Water District superintendent, but then he's purchasing it as the co-clerk of the Watershed Protection Commission. And I've suggested over and over that maybe Kevin could step in and do the land transaction part as Lewis's co-clerk.
Is he purchasing or is he negotiating? And is there a difference? I don't know. But he's negotiating. We're purchasing, correct?
I mean, I just personally think, it's an issue, and,
Well, whatever capacity any individual besides the commissioner is whatever role they're playing in this organization, right? It's because they've been chosen to play that role. And I don't know if Sid's appointed by the commissioners here, Lake Auburn Watershed Protection Commission. If they make that decision on who their clerk is, I'm assuming that they do. I think that would be up to you guys to decide. Certainly, if you ask me from a practical perspective, it's easier to have the person familiar with the property to sort of play that role. If one person is in charge of regulating the property and understanding what's going on there, then they might be the appropriate person to carry out the transaction.
although there is a property folder that could be just handed over.
Well, and are we talking about a ministerial role? I mean,
It's a big word for me.
so.
I was thinking that too. Thanks for doing that, because I wasn't going to.
So,
You can't look it up, I'm just kidding.
Hey, Google.
you might say, Sid, we want you to advise us as to what the property looks like, what the issues with the property are, give us a recommendation, let us know if you think this is a good idea to go forward. Because you're familiar with it for the other roles you play. He can come to you with a recommendation. You need a clerk appointed, right, to actually put the legal signature on the document. That's a ministerial role. Okay, a clerk is bound, duty bound, to fulfill the wishes of, providing its lawful request, to sign that document if the commission voted, sign that deed, sell that property. That was the decision of the commission. The person sitting in that clerk position, in that function, doesn't have any discretion to say, no, that's a bad idea. Okay? They are duty bound as clerk to carry out and act on behalf by putting their wet signature on that page.
Within the limits of what we've.
Right, and it would be a violation of the clerk's duty to act beyond the scope of authority granted to him on any particular issue by this body, just as it would be a violation of the commissioner to make promises on behalf of the organization that weren't adopted by a majority vote.
So maybe, Dan, we can take this up another time, because I think
Yeah,
it is a good
that's
one,
fine.
but I think there is a, maybe, we do have two clerks, we can assign clerks if we have history. You had mentioned some history in the past. That doesn't mean Sid has to do them all, we should talk about it.
It's nothing against Sid, I'm telling you. I've seen some past dealings. I mean, just a quick example, the Disjardins camp, when there was a family problem, the LAWPC went and purchased half the camp from the disgruntled family member. So now LAWPC owns half a camp on Spring Road, and the other half, the brothers are like, hey, we got screwed, because we should own this camp. It was handed down through the family, So, and Sid wasn't even around when that happened, but it was a former superintendent and a former clerk that did the same job, Anyway.
Well, that's a bigger discussion for another day,
Yep,
probably.
That is a
Bigger
big
discussion.
And an interesting issue to be sure.
Cool. As we do have a lot more to go, does anybody else have any questions for Jim today?
That was great.
If we have a question for Jim, could we, Sid, would you mind collecting those? And if somebody said, geez, Evan has another question or something, could you send it through? Just make sure that all the commissioners see it.
Well, thank you all
Thank
very
you.
much for having me.
Thank you.
We learned to do work, didn't we, Dan?
Ministerial.
Gonna have to remember that one.
Spell them out, spell it
I don't know
out.
how to spell. Sounds very, Erica, you want to go through the water quality
I just
update?
want to make sure you had it. Yeah, I'll take that.
So, first bullet on here, courtesy boat inspections. So, I know we have some new commissioners, so Lake Auburn is considered an infested lake with milfoil by the Maine DEP. There is really only milfoil in the most northern point of the lake that connects from a stream that comes out of the basin. So the basin has a lot of milfoil covering the bottom of it. Some of that has come down over the dam into the northern part of the lake. So because Lake Auburn is considered infested by the state, we can receive grant funds on an annual basis to have a courtesy boat inspector based at the Route 4 public boat launch, checking boats and trailers as they come in and as they come out. So we have one person right now working as we call them CBIs. So she's there from 6 a.m. to noon. Her schedule is a little funky right now. She's a high school student, so it's going to be picking up in the next couple of weeks once school and softball is over. And we're looking to hire one other person, and we had another high school student apply. It's a really good gig for high school or college students. It's basically Memorial Day to Labor Day. You're checking these boats and trailers coming in and out for invasive aquatic species, and also you may have heard of zebra mussels. There's a couple other species that aren't plants that we also are checking for. So we don't have those infestations developing in the lake. We also have posted the education and outreach position. So Sean Siri is no longer with us. He moved on, and we just posted that position last week. And again, if any of the commissioners or staff know somebody who might be interested, please pass that posting along. Both of these postings are on Indeed. So we'll be looking to hire for that position again. It will still be a part-time role. We may revisit that next year. That would be a discussion between myself and Sid and Kevin and probably Mary Ann about funding that position if it can change at all. Or there's also been some discussion about if it could become a 40-hour position, we would have half that time for the watershed, half the time maybe for City of Lewiston Water and Auburn Water. So those are two current postings. Southern Link Trail, Actually, last week, we received a notification from the city of Auburn that Senator Susan Collins had congressionally directed spending request out. We found out, I think, a day before the deadline of it. But we were able to pull together a grant application for the Southern Link Trail. We have not heard back about, if we're going to be awarded those funds. I think it will take a little bit of time. But we did get that grant application in. And there's quite a bit of money in the millions to go around for that. So, we'll see what we get. It would be great though. There are state grants available, local funds available, but we've got a big federal grant that probably speed up the process of developing this trail and just get things moving more quickly. For water quality data, I'll give you a current update, and then there's also some graphs and charts in here that I'll go over. So our lab staff went out on the lake today to do in-lake sampling. Our current turbidity, which is not sampled in the lake, we have online meters in our raw water building, is about a 0.5 NTU, which is normal for us for this time of year, for most of the year really. Once you get into mid to late summer, things might start to change. You might see that number go up, but this is pretty standard for us. We have a 10 meter clarity reading, which is really good for this time of year. And some of that, I think, is we're in a drought. We have not had a lot of rain, a lot of water coming in from tributaries. We don't have a lot of nutrient loading or anything coming in right now. In this time of year, it's a good clarity. You can see pretty far down in the lake. Late summer again, when stuff starts to grow, that starts to change, so that's normal for us too. So I'd say we're looking good right now. I talked to our lab staff this morning. Our last 2 rounds of phosphorus data, which get collected in the lake and get sent to the State Health and Environmental Testing Lab, were mishandled or something happened at the state, and this is highly unusual and it is very frustrating for us. And they've had a lot of staff turnover at this testing lab in the state. I mean, we've been doing this for years. We bring up the samples, we know the people there by name. So that was a major problem on their end. However, we took samples today, again for phosphorus, drove them up to the lab. So hopefully I'll have those numbers for you and many more weeks of phosphorus data for you at our next meeting. So right now I have through, I think, April in here to share with you guys. So in this packet, you'll see one of these kind of funky looking charts. The very first one in here is temperature. And it is small print, I realize that, but it's a full, 365 days worth of data over the last few years. So on the bottom axis, you have calendar day 1, so January 1 through calendar day 365, so December 31st. We have 2017, 2018, 2019, 2020, and 2021 lake temperature. For your reference, the orange line is 2021 lake temp. So you can see we're a bit elevated, and that makes sense because we've had some intense above 90-degree days. So this is warm for this time of year. Later this week it's going to cool back down. We'll expect that to get back down. But this is just for your reference, year over year, the past, including this year, past 5 years, worth of temperature information. And you can see the seasonal pattern. So
Eric, did you say where we are? Are we like 160 or the day of the year? Are we?
day of the year, just about, yeah. So where are we? June? Yeah. Basically, not far past where the orange line ends right now.
Okay.
I think we're a couple days after when I grabbed this. So.
Gotcha.
What's the depth of this temperature reading?
So this is actually taken in our raw water building. So it's water from the intake.
Okay.
So how deep's the intake? Is that 20?
5 meters? Yeah. Yep. So that's for historical reference. You can kind of see the seasonal pattern there, and it gives you an idea of where we're at right now. I know last commission meeting, some of the water quality data was requested, so it's kind of a background for you and a snapshot of what's going on right now. The next graph is our turbidity graph, and you have calendar days of the year again on the x-axis, and you have NTUs on the y-axis, so that's our measurement for turbidity. Just for reference, we lose our waiver if we ever were to pump water of a 5 NTU, which we don't. The plant shuts down before we ever hit that. And right now we're running a 0.5 NTU, so just point of reference there. This also has 2017, 2018, 2019, 2020, and 2021 on there. The 2021 is kind of hard to see. It's one of the darker blues, but it's following the trend line that we've seen the past few years. To stand out on here is the green. That was 2018. That's when our turbidity started to climb in the lake, and that was caused by a blue-green algae bloom. So that triggered Auburn Water and Lewiston Water to make the decision to apply copper sulfate to the lake to kill off those blue-green algae, which can be noxious to people. So that's kind of an outlier year here. What we're seeing this year is more of a normal trend. But again, late summer is when we start to see those big changes, so I don't want to say that it's going to stay the same. It really is a year to year. Next, you have a map here, and again, it is small, but you'll see these little numbers here in the lake and in the watershed. So those are all our sampling sites. So all of the in-lake sites get done once a week. Tributaries, typically every other week. If there's rain events, those will also get picked up. And I threw that in here because once you get to our next table here, so this is in-lake sampling phosphorus results, okay? And we have our site locations. So we have site 12, site 30, site 29, site 32, 31, and 8. I think what might be important for you guys is that site 12 is our intake. So that's a sampling site that we collect water quality data from every week. And site 8 is the deepest point in the lake. It's the deep hole. It's 33 meters deep, and just for reference, so the intake is 4 meters deep.
Yeah, and site 4 is the one up by the basin,
Yes.
just for your reference.
Yes. And so you have your sites, and there's two methods for collecting water quality, for collecting water to test for phosphorus. You can drop the sampler down to 4 meters, grab water there, bring it up, and run that. Or you can take a tube from the surface all the way down to 4 meters, so you're getting a column, you're getting all of that water mixed together, and you can run that for phosphorus. So when you see core here, that's that tube going all the way down, you get the whole water column. The blank is when you stick a sampler down and you grab the water from 4 meters. It's not representative of the whole water column. So we have those methods at each of our in-lake sites, and you have total phosphorus, it's the second to last column, and orthophosphorus, which is the last column. So for us, anything really on here under a 12 is really good, and these are parts per billion. So there aren't any red flags that we're seeing from our phosphorus collection this year. And ortho, anything under 1 is great. That's the usable phosphorus. So if you get up to a 3 or a 4, that's concerning. And we'll see some of that in our tributary sampling. So again, this is just in the lake. I have a couple days worth of data. I'll have more at our next meeting with the exemption of our last 2 rounds. The next set here is our tributary sampling data. And so on that map, kind of if you orient yourself here, above the clothesline, if you go north of that, you see a small 25 and then a couple of pink boxes. So that's the Blanchard Pond system that we had a meeting about a couple of weeks ago, okay? So you have site 25, that water's coming right into the lake. R2, which is a culvert under Route 4, and B1, which is Blanchard Pond itself.
Erica, can I just, you may have said it this way, I may have missed it, but total phosphorus is parts per billion and orthos parts per million, right?
Yes, and I did not say that, thank you, Dale. So in that system of what we call B1, R2, and 25, so Blanchard Pond, Route 4, and 25 is coming into the lake. you'll see those site locations listed on this table. So 25 is coming to the lake, we see higher levels of phosphorus and orthophosphorus. And it's pretty consistent during every sampling date that from Blanchard Pond to Route 4 to 25, where it comes into the lake, we see higher phosphorus numbers than we do in other locations in the watershed. It's not to say it's the only problematic one, but I've highlighted those for you for reference. It's kind of a chain that you can watch happen. So that continues on to the next page. And I think that's important because we did just have that meeting to talk about that study that was done. And I think this indicates that that system needs some attention. And, you know, whether it's buffers around Blanchard Pond, doing some stream bank work, where the culvert's coming out from under Route 4, I think those are two good options, and we should address it. And I know that from that presentation, you guys learned that this might not be the most impactful system in our watershed, but I also don't think we should ignore it because the potential, the land use there, the potential for this to be bad is there.
And phosphorus is cumulative, right? But I mean,
Sorry?
any source, phosphorus is cumulative, so any source we remove, especially if we have low cycle times of the lake, which we seem to be having, any contribution is good if we can remove it at a reasonable cost.
Exactly. Yep. On our next page here, we have a small table. That's our.
Dave, do you have something?
Yeah, just a quick question. I've just been thinking, you know, of a greater scale of water quality improvement. What's the correlation of raising the lake 2 feet? I know Harry Walker's parcel, he's a very old fellow, but I know there's some restrictions on what our maximum lake height is.
Mm-hmm.
But if we were to acquire that parcel, let's just say hypothetically, you know, in the next 5-10 years, what would 2 feet, or what, I don't know how much more we could go because of Harry's land, what would that do for our intake being lower, the water column? Would it make much of a difference?
You know, that's a good question. I don't know, because you would essentially be adding millions of gallons of water to the source.
Well, actually, CDM Smith addressed that in some of their post-study, and they talked about the lake kind of looks like an upside-down witch's hat. So extending that brim out further just it creates more warming because it is shallow water, so you're not getting a really cool depth. I mean, if we could make the deep hole bigger, that would really help.
That would do it.
Yeah.
But we did try that a while ago, withheld water, had it, you know, dilution, solution, pollution thing,
Right.
but we actually created warmer water in that upper layer and maybe exacerbated it. So their recommendation was to actually keep it at that level, out of 01 and things like that. The warming is kind of minimized because we're lessening that brim of the hat.
That's a great question.
Thank you.
Yeah.
So our SECI disc data, so anybody who's not familiar, it's this round disc, it's a black and white check, and you drop it down off the side of the boat into the water. You have a scope that you're looking at in the water, and you drop it down with a tape measure to the point where you can no longer see it. And so to the point where you no longer can see it, that's your clarity depth. And we record that in meters. So throughout April, it was roughly around a 9. Today's reading was, I think, a 10.6 or 10.5. So again, that's several meters of clarity. That's an indicator of good water quality. When you lose your clarity, it means there's something typically growing, or there's something suspended in there that shouldn't be in there that's going to cause a decline in your water quality.
Should roughly relate to the MTUs, right?
It should, yes. Yep. Typically, if you start to lose clarity, your turbidity is going up. And the last few pages here, I've included January through May for your reference. These are our fecal data, total coliform data, and E. coli data. So these are taken every day. For your reference here, majority of the time, we're getting zeros. It's not unusual to have a couple days out of the month where you do have some positives. That's really more for your reference, and it indicates good water quality where we're not seeing much of these different types of bacteria in our source water.
What does that number represent? Zero,
So-
is it just a binary yes and no?
So for the fecal, it's colony forming units. So
If you put it on each, it makes more.
Right,
Yeah, no,
exactly.
Yeah.
And
So
then,
it's each one more, right?
yeah, and so, you see one of the months here, let's see, January, one of the days we had a 5 for that. So it can go, we had some 1s, some 2s. Where it says 20 tray, the total in E. coli, that's a most probable number. So honestly, you're looking at these different pockets in this method that you use in the lab, and you have this chart, and it's basically, if you see 1 out of 30 of these, it's a multiplication factor, so it's most probable number of colonies.
Historically, we've seen it as a result of the bird migration.
Yeah.
And later ice on kind of perpetuates that. So, depending on what's happening, early ice off, early ice on, and it's more regional. So if the northern lakes are frozen, then we may not freeze for a while, then those gulls may hang out here more. So that is typically when we see those numbers get elevated.
Yeah. That's my list for water quality data. Anybody has any questions, feel free to reach out to me, and I'll do my best along with Chris Curtis, he's our water quality manager, to answer your questions. My next bullet here is priority sites, and I mean that in the sense of priority projects to address in the watershed. That's my other large document included in here. So I put this together last year in 2020, and really the most important of all of these is the last 3 pages, but just to show you for reference, I had said in one of our last meetings that there are many studies that have been done on Lake Auburn in the watershed in the past 10 years, past 11 years. So each of these documents was in a header here. So our first one is the Lake Auburn Watershed Management Plan, done by CEI in 2010. These are some of their recommendations and notes. In here I have if we've addressed them or not, and further detail for notes.
What's a star, I'm sorry?
Yeah, so on that one, those are if we've accomplished them or not. So we have, first one is our Lake Auburn Watershed Management Plan, a diagnostic study of Lake Auburn, part 1 and part 2. Yeah, I know, this is more for my reference, but just to show you guys, these are the documents, this is where the information is coming from. Here's a Townsend Brook phosphorus study done, diagnostic study 2, and then we have Waters Henderson's recent thesis included in here. These are all the recommendations, and really the last 3 pages of this is the priority to-do list, okay? So this is what we can be working off of, but also considering things in real time. So if our lab staff go out and identify a source that's extremely high in phosphorus, okay, that might pump up the line. So this is kind of a working list of recommendations from all of these studies and plans that have been done. So just, you have that for reference now. It's something that we can be working off of with the note that some of these were done in 2010, some were done in 2013. We have more information now, and things change. So that's kind of a background for your reference. And with that said, this year, I'm looking at doing some improvements on the Spring Road with culverts and ditching and crowning the road and improving the drainage that's coming towards Lake Auburn, and hopefully minimizing the amount of erosion that's going on and sediment transport that's going on. And I talked with Lewiston Public Works about doing that, so hopefully we'll get that project going in the drier season. I mean, we're in the drought anyways, but later summer. And also, I'd like to work on the Blanchard Pond system as well this year. So any questions about any of that? I know it's a lot.
That's a cool summary, thank you.
Yeah.
Okay, we got a couple more agenda items. I know we're running a little late with Jim's great presentation. Is everybody okay with powering through the last few, or? All right, Perkins Ridge recommendations. Looks like we have a chart in here, a request on it. Sid, did you want to, or Sid or Dan, or both?
Sure, yeah, the
You guys wanna know what?
The last meeting we had, talked about this issue. It was tabled pending a map. The last meeting we had, Dan provided a map, wanted it transposed onto our GIS map so you could see the true scale of what this proposal was going to be. So that's what is in your packet. I don't know if anyone has a copy of that. But that was put onto that map, and I guess with that, we can pick up the discussion again where we left off.
So one thing we talked about was where the water district owned to the center line, or the supposed center line, as the road was discontinued. And the only, do I am I understanding this, that these are the two parcels right here, or segment, this is the segment that we're probably really have authority to focus on?
There were two. There was one near the middle gate where the commission did not own either side of that right of way.
But we only own to the center line along everything except these two, where we would now presumably own from both sides to the center line.
One of them was the Como camp, and the other one was there's one right in the middle, kind of in the middle of where that diagram is, the Discharge camp. And the one up towards the middle gate, which was the
Little piece here, little piece here.
Como
So
property.
there's only two parcels that LAWPC, there's only two areas which I have local permission from those landowners already. Everything else is gonna be east side of the Spring Road, which is what LAWPC has their rights and ownership on.
But these are the only two right here where we would have control of the complete right of way. That would really be,
Oh, okay, yes.
I'm saying it the other way. I think
Gotcha, yeah,
we're
both
talking the
sides.
same thing, just opposite
Right,
sides of it.
yeah, gotcha, yeah.
This is really the place where we should need to discuss, right? Because the rest you could avoid any LAWPC property by swinging to the right or left.
Right.
Did I get that right?
Well, this is the one location where I can go east or west side.
Right.
Traverse.
Well, what Dale
I
was
think
saying.
the other way around.
Dale's saying, this is the only thing that you can't avoid without our permission.
Without our permission, right? This is really what we need to focus on right here. Is this.
But I can't do any of this without the permission of all these other.
Right.
But that's not in front of us.
But Dale said like that, you could go.
Our decision making is really
It's
related to
related
this.
to our property only.
Right,
Our
and the
discussion-
There's two different ways to look at it.
yeah, and the property on the
Exactly.
east side,
Yeah.
and the property, yeah,
Right.
okay, yeah, I guess, yeah.
Without our permission, if this little piece in here didn't exist, you could seek some pathway through, whether it was right or left. This is the place where you really presumably need our permission.
Well, I would need your permission from here to the south gate as well, so I could traverse on the east side.
But you could traverse on the west side.
I can.
Because all these.
We don't
people-
own
Because
the
every
west side.
single one of
I
those
know that.
landowners, every
So
single
we
one of
have
those
to go on this
landowners would require permission, and there's
Right.
already one or two that are not interested.
All I'm driving at is, you could do that. This is the one place where you definitely need ours without seeking someone else's.
Well, because he wants to go on this side though. So
I know
we
he-
need
I
to
know he-
permit
I
this
know he
and
wants,
all
but-
that.
Right, okay, I'm seeking permission to go
Yeah,
between
I gotcha.
the middle and the south gate
Right, the
Right.
whole.
on LAWPC property. So whatever you guys own, that's where I could traverse.
Gotcha.
That's what I would traverse on.
Okay. I think we just, yeah.
So you would go like that, like,
There's only one place where I would shift.
right. just-
But in fact, I don't need to. I mean, we have the east side from this big white triangle, so we could just stay right on the east side the whole way. The only thing is, to get around the gate, the middle gate, it's already set up on the west side, where you don't have to do anything, we just go around that, unless we open both gates, but there's no need to open any of the gates. Like the north end, we don't open the gate, we just go around it.
That's an item we should talk about a little bit, yeah. All right. All I was saying is you could, if you got those permissions, you could seek permission and avoid us except for these two locations.
We're a volunteer group. That,
I'm not saying you should,
Yeah, I know,
I'm saying but you could.
We don't have the resources to
I'm
do
not-
that.
I'm not
I
saying
mean,
you
it would not
should.
benefit the public.
That's not what I'm saying.
Okay.
What I'm saying is, we can't,
I
if
feel
we
like
know,
I feel like you're asking me to seek permission.
you're not, I'm not,
Okay,
I'm
so,
not, let
all
me
right.
finish.
From those
Yeah,
other.
our jurisdiction could only be there. All I'm saying is, the reason, if we didn't exist, if those two lots didn't exist, you could go somewhere else and find another way. I'm not suggesting you do that.
Right.
I think what Dale is trying to get at is that those two pieces of property are what necessitate that
This
you
conversation.
ask permission from the commission,
This conversation,
regardless of,
Yeah, I just never thought of it that way. I just thought of the easiest way to make a public benefit.
I like to whittle things down as small as I can,
Yeah.
right? And then,
Especially when we work with volunteers.
yeah, especially work, but I also just want to make sure, you know, within, you would have other means without us if it weren't for those two. And I just want to make sure that we're whittling this down to something where, is this really, what kind of what size of issue is this?
Yeah, so the only means right now is to traverse the lake on the ice, which it's been marginal at best.
Yeah, I think what Evan said is what I'm driving at, is just that you could ignore the commission if it wasn't for that. You know, and not going to the lake, but you could if they were all happy property owners. All right, I guess the other thing I'd just like to ask,
never gonna get permission.
I don't know,
That's my house.
Oh.
there you go. I'm sorry, there's three then.
Yeah.
So, I guess one thing I'd just like to maybe talk about, have the commission talk about before we get into, you know, whether we really want to do it or not, is really those gates, as Dan said. I mean, is there I guess I personally have concern about going around the gates, because I think if we were to authorize traversing our property, I am worried about others traversing our property if we go around the gates. I personally would like to give you a mechanism to open the gates and close the gates and pass, and I don't know how the other commissioners feel about that. But.
It's not difficult for us to do that when we're only doing it 2 or 3 times, maybe 5 times a year.
Right.
It's just the middle gate got snow plowed up against it, but we have a plow on our Rangers, so just to be a little bit of extra training to the other groomer operators.
So Sid, is there a mechanism we could daisy chain locks in that provide them a lock so that they could?
One thing I
traverse it?
added to this map was PRST to provide locks for both middle and south gates. Because, yeah,
Which would be daisy chained in with ours, so they could go, we could go, we don't have to ask them, they don't have to ask us, right? Was that what you meant by that?
yes, as opposed to the alternative of going around the gate, as you mentioned, that probably wouldn't be ideal, because that would
Yeah.
make a path and invite others, before you know it, that would be a snowmobile trail.
And we might have some unhappy neighbors. I guess, how do the commissioners feel at this point after the work that Dan and Sid have done about allowing it the few times a year? I think you said 3 to 5 times a year. Feel about
I have, because I remember what we discussed last time as well was when we had Norm look at it, saying that was, the overburden of the easement. Does this address those concerns that the attorney had?
So
Yeah.
that's why I was driving to these 2 properties, right? We only really have authority over the entire right-of-way in 2 places. I think that's what I was driving at earlier.
Yeah.
I'm not suggesting you go out and ask a bunch of property owners, but we don't have authority over that entire right-of-way. The only place we really have authority over the entire width are those 2 locations. So I think by not precluding us, or precluding him from doing it, I don't think we're overburdening it. We're not giving permission, we're not restricting him. I think that's the way. That's my opinion. I don't know if it's ever.
Yeah, I don't think we're overburdening because we're not giving permission to utilize our easement rights over someone else's property.
Exactly.
We're giving permission to traverse over our property,
And that's
over
why,
which other people have easement rights.
exactly. And that's why I think that's why these 2 are key, back to the original conversation is,
Yep.
this is the only place where we could just say no, right, because we own it, it's not allowed, but except for those people, as Evan said, the other people that have easements would still retain their rights. We're just not saying no over the place where we have control, complete control. But you and I say about the same thing, or close to?
What? Yeah.
Did you and I say close to the same thing? And that's why I was focused on those from the beginning. It wasn't because of anything else, but it was that whole easement. But it doesn't have anything to do with the easement. We're telling them they can traverse all of our property. We're not precluding them from traversing our property, our fee property.
I think in making decisions like this, we sort of need to think, is there, at minimum, it must do no harm, right? So ideally, you would like every decision you make to have a positive, affect a positive outcome. But I think as long as you're doing no harm, then that's sort of the minimum litmus test for me, anyway.
Sounds Hippocratic.
Yeah, and I would say, right? Yeah, exactly.
Not Hippocratic, but Hippocratic.
Yeah. I guess I don't see a detriment to our goal of maintaining the quality of the lake by doing this. And I think it also does a favor for someone who and I know that we give them permission to groom the north end, but the reality is, I think that they're actually doing us a service. I think one of the best ways to get people to care about the lake is to get people vested in the area. I think that's why sort of the trails and systems and things are important. And so I actually look at that as a positive benefit for us. You know, that there's winter usage there. Living down here, I know that a lot of people like to snowshoe, ski, fat bike. So when there's a lot of people out there, you know, people care about the area and they're checking things out. And I see that in the summer, you know, people walking and picking up other people's dog bags that they left. So I think the club is sort of already, I mean, they're getting something from it, we're getting something from it, they're asking for permission to do something. I don't see it doing any harm, so I guess there's a long way of saying I'm in favor of it, essentially, because I think it's mutually beneficial. It doesn't harm the lake.
Anybody else have any thoughts? I guess, you know, would it be appropriate to entertain a motion that we have Sid write up an agreement, or someone, Kevin, or one of our clerks, write up an agreement, working with Dan, for a couple of things, to give them permission with some parameters around them, like the gates need to be open and closed, they need to do what they can, their part in good faith to keep snowmobilers, just other people off. I mean, they can't control it completely, but do a good faith effort. And that there is, if there were to become a problem or a public outcry, that we would have the chance to revoke that permission. Is a motion like that be something reasonable for us to instruct our clerks to work with Dan's group on?
And bring it back to the commission.
And bring it back to the commission.
Yeah, so the commission would have a look at the final agreement itself.
Yeah, and back to the ministerial duties, we would then give one of the clerks permission to execute that agreement once we were happy with it.
So I'm hearing concerns about the possibility that it could encourage inappropriate usage of that section of the road.
That is my big
And I think-
concern, yeah.
So I think, and I don't think that the snow travelers will have a major objection to this. I think it would be reasonable to say that we build into this agreement that this is an annual agreement.
That'd be very reasonable.
Just because I think that if it's an annual agreement, it does two things. It gives the commission the ability each year to essentially change its mind without having to go through the
Revocation.
right.
I kinda like that.
And it also gives the club the opportunity to rectify incidences. So if there was something that were to happen early on in the season, we might be tempted to revoke permission, what allows them to make the good faith effort to show that they're committed to maintaining the agreement.
Overestimate the speed of government, but yes, I agree with you.
Yeah.
There's a current agreement that could be amended as well if it helps Erica with the paperwork with the club.
On the north end, or?
Yeah,
Yeah.
all our trails have an agreement every year, recycles.
Clarity, not us rectifying, the club rectifying, they're a private organization.
Yes.
They can work quickly, yeah, I would feel like with government.
Yes, they can. Yes, you got it, yes. I would like to think we could, but we can't sometimes. Sid or Kevin, how are you feeling?
I wanted just clarification on the proposed use change. That's just for traversing, get the groomer from one point to another point. You said 5 times, like about 5
Yeah,
times.
and we either tow a roller, which is not good to be on the road, it's just a plastic roller, PVC, or we tow the drag behind the groomer.
Yep.
For trail maintenance, we could write for trail maintenance purposes or something.
And we would be even willing to have a handout if we do encounter, the only unauthorized, we had a couple snowmobiles last year go around the gates, I don't know if Sid told me about that. Eric had reported that, but, you know, if we see something like that, of course, we would be able to, it's such a small family trail anyway, so we're gonna find out whose parents we need to talk to about, you know, I mean, they say stay the hell off the lake, but that doesn't mean go on private property that they're not authorized to be on.
Is there signage that we could put there or that you could put there?
There is
with the
signage
club
there,
that
no
could say
motorized
that?
use, that was put a couple years ago.
And of course, there's the pictograms, right? No snowmobile with a circle and a line. It was, it's a 1960 snowmobile, but, you know, could, I guess maybe the agreement, signage and other educational things that they could do. Again, to rectify it or prevent it.
The plowing, I know right now, we plow in and plow right up to the gate because we've never had to worry about anybody going through the gate in the winter. Did we look to see if we could, I mean, knowing that somebody's going to be going through the gate, push the snow off to the sides rather than, obviously, if we know you're going to be going through it, we're not going to bank a big snow banking right up against it. But I don't know, Eric, I haven't been out there in a while. Would we be able to plow to the sides and then still have room to turn around the truck and then get out? I guess I'd want to look at that.
And I would want to look at that too.
That would
If
be
you
my.
plow it the same way you plowed it the last 2 storms, where you pushed it all where
Around the gate, yeah.
around the gate, that would leave the gate easily
All right.
traversable.
And then by them doing that, they still had room to turn around and then get out.
And that would block the ability of a snowmobile trying to get through.
That's
Or at
my.
least it's something for them to say, oh, okay, trail ends here, that's the sign. Yeah.
That's the only reason I bring that up. I just want to make sure
No,
we can still do what
Could
we
be a
need to do.
challenge too, right? Kids. I know what I was like when I was a kid. I think that is my snowmobile on that picture, by the way.
I have no issues with it, man.
You do?
I don't have any issues
Oh,
with
okay,
it.
okay,
So I
sorry.
think logistically, you know, the keys to the gate, limited staff, for both utilities. Because we don't want a staff member choosing to go use that on their own hours and get some private benefit, so.
So is this common-
Off-season, we could take that lock off,
Mhm.
and that way there would be no accusations or somebody saying, somebody.
What happens in
some-
summertime, right?
Right, right.
That would be good for PRST.
Maybe
Right.
taking the lock off.
Taking the daisy chain off, what we're proposing, and just
Oh,
doing that for
okay.
winter conditions.
I was actually, as you were saying, I was just writing.
So
down.
maybe in
Have a
the, so
date.
maybe in the agreement, Kevin, you know, we talk about them providing a lock and one key to the district, so we have one as well, right? You know, maybe that's part of the agreement. If they provide the lock, they provide us a key to that, each of the locks too.
We
But you
shouldn't
keep
need, we
the
shouldn't need
office.
their key if they daisy chain it.
Yeah, we really don't.
Yeah, but if you want to remove the lock, if you have a problem and you want to go out and remove their
Oh.
daisy chain,
We can do that.
I think they should provide. The agreement might want to say something, I don't think we want to revoke, but I think if there's a problem, or in the spring and fall, we should just have a key for a variety of reasons. That should just be an agreement. They provide a lock and one key, the water district don't put under ours. I think that's reasonable.
That's reasonable.
So I'll make the motion.
Please.
Two.
Maybe wait for dinner. The
You
third-
have to read.
Dinner night, dinner in the third night in a row, yeah.
For the agreement to give Sid or Kevin, or both, to draft the agreement to bring back to the commission based on the conversation we've had today.
To include them providing locks
Right?
for traversing of snow maintenance vehicles on a limited basis from the lake is inappropriate, or not appropriate, however you guys phrase it in good English. And that would be, we, the commission would renew that on an annual basis.
Yes.
Is that, did I get it all? And then,
Yeah.
Amy? Okay. Anything else you guys think of or Dan thinks of that we should?
I would ask that, maybe I missed it, that to pass through but not around the gates.
I think, yes, no. you
So
did-
traverse, but not just to traverse.
Through the gates, right?
Through the gates, yeah.
And take good faith effort to sign and to, like Dan said, investigate or manage snowmobiles to the ability, in a good faith method. You know, you're not gonna go to them all, but I think through signage and through education or through outreach, something like that. I think that's a good point too.
Okay, so,
Kevin can repeat it.
well, no.
Do you want me to repeat it? Because I've been keeping notes.
Yeah, I was gonna say.
Motion for a
Mr.
clerk to
Whitmore.
develop a written agreement between LAWPC and PRST to include locks, snow maintenance, annual agreements, and through the gate passage only. Motion was made by Amy.
And I think we mentioned revocation of the agreement upon,
And the unlikely event, yeah, I would say unlikely, but
unlikely, yeah, but just to have that in there in case,
just in case
Yeah.
it becomes very
Right.
egregious.
yeah.
Added.
I think that's great. So, we'll take.
I'll second that.
Okay. All in favor? I assume there was no more discussion, I'm sorry, I skipped it.
Dan, you abstaining?
Yep.
Might be good to recuse.
Accused, abstaining,
Yourself.
all that stuff.
Both.
I didn't hear you, I'm getting old. Plus, we had a council meeting till almost 11 o'clock last night. Wow, today. All right, one more item, sorry, then, public comment things, but Sid, land negotiation, updates, briefly,
Yes.
please?
Need a motion to go into executive session?
Is the camera still on?
It is, but you need to take the
Well, we need
motion
a
vote.
motion. Somebody needs to make a motion.
I make a motion to go into executive session regarding negotiations of potential land transaction in accordance with 1 MSRA, section 4056C.
Seconded.
Any discussion? All in favor?
We're out of executive session.
Thank you, sir. Open session of the public, we have no public members of the public here. Open session for commissioners, do the commissioners have anything else that wasn't on the agenda they'd like to discuss today?
Yes. At a previous meeting, we had mentioned the possibility of essentially creating rules of order for ourselves. And I think that staff did a great job putting some things together. I think it creates a really good start, foundation for that. But I think I'm still very much of the opinion that there could be some additional, some additions. And we had discussed about putting that on an agenda, I believe it was possibly the last agenda. It didn't show up, I didn't say anything, so I assume maybe it made it to this one. But I'd still like that, to be visited. I think it would be helpful for us to have a document similar to what the water district has actually. I think it might be the best way to go. But,
Do you think we ought to start with that as a foundation, the water district one? Because I had a couple thoughts, but that one might be more applicable.
You know, I picked that one only because I looked through a few. I mean, I've got others that I use on other organizations. But looking through the water district one, it seemed that, well, if we are really as closely aligned with the water district as we are, it makes sense that we ought to have documents that are not at least visually incongruent.
So would the suggestion be that Sid pull that up, run it around the commissioners, and as you said, for a discussion, put on the next agenda? Does that make sense?
Yeah, I think that makes sense. I think that, and I can bring it up again next meeting, I think it'd be good to have a discussion amongst the entire commission, but I think it would be difficult to create a workflow in which the entire commission goes through and creates a document based on that. So we might want to visit the idea of or asking a few people.
Personally, I think that's a great idea. I think, but it would be nice to kind of start with commissioner thoughts, right?
Yeah, absolutely, yeah.
Then they charge.
Yeah, no, without that, it's difficult as well, so.
So why don't we do that? Any other items? I have one.
Just the one from the Jim Cross presentation. So can we ask, you know, I mean, it doesn't hurt asking to turn it to be sensitive to our lake by maybe starting to get through planning board. Some of the information that Eric is providing the commission, we can start getting that to the planning board members. So that maybe they might do something to help us out on this end.
So can we add that to the next agenda about what we provide and what that request might be? Does that sound good?
Yeah.
Yeah.
What is the phosphorus loading from that end of the lake? Is it?
20-30% from the
Yeah, it's
basin,
a
right?
Chunk of the basin, it's a large percentage, right?
Townsend, and
Coming from the, coming from the basin.
From the basin? I'd have to look.
It was in,
Yeah.
I think they had it in the last,
Yeah.
what's
They
it?
did.
It was quite a
Dan's
bit.
study.
Oh,
It's
Townsend
one of
did
the
to
bigger
that.
contributors.
It was one of the bigger.
That was sort of eye-opening when
Yes.
Jim said that. I said, wait, the water district can do that? So that,
Yeah.
wait. LAWPC can compel the water district to do that? Okay.
Might not be a popular thing, we should talk through that a little
No,
bit.
it- no,
but
it's-
I definitely, something to explore.
Well, I think what it does is it creates a situation where, when you go to Turner and say, we'd really like you to be thinking about this, there's a reason maybe for them to take it a little more seriously if they think that something like that would be all. And I agree, I think
It'll be interesting.
it would be less than ideal.
But that's something we should talk about.
One thing to following Jim's presentation, would the commission like to start or have an interest in looking at the existing bylaws for protection of Lake Auburn?
Yeah, I thought that was an excellent idea, Sid, especially if you guys are going to be reviewing them, and I think Jim Brown can point that credit to get down.
Want that as, action now, or just to put it on next?
I think it should go on, I suspect, I don't know. What's your timeframe, Sid?
Well, we've talked about it, we haven't, the trustees haven't taken any action on it, but it has been a topic of discussion.
But my presumption it'll be a while, right?
It's basically tabled until the city of Auburn comes out with
Finishes
a
the
study.
study. Okay.
That update's gonna be June
Yeah,
22nd.
as a matter of fact, that's one thing I wanted to bring up too. June 22nd, there's gonna be a workshop at the Auburn City Council chambers where they're gonna be talking about the Lake Auburn study. The consultant is gonna be presenting their findings. It's gonna be the first public presentation of that study. So I would encourage anyone on the commission to attend that workshop. It's going to be very informative.
So your question said, I think yes, I think we also ought to put that, it's gonna be a very substantive meeting, we probably won't get it all done, but I think you ought to circulate the bylaws to the commissioners, if everybody in agreement. We bring some overall thoughts to the next meeting, and it may take more than 1 or 2 meetings to actually craft a recommendation, but I think we ought to start a conversation, is everybody kind of in that?
Yeah.
But I think you're gonna have to circulate it soon, because that.
Yeah, we have to get it sooner than later.
Yeah, yeah.
And I don't know how we want to go through it. I found in the past, in going through larger documents, like for instance, entire sections of ordinance, it helps to have sort of those overarching recommendations, but also sort of chunking it out and saying, okay, at this point we're talking about this type of section. It can be useful because sometimes you'll separate through those and say, everyone says, no, good, we'll hit a specific section, and if
Yeah. So I think maybe if Sid gets it out, maybe commissioners could get back to Sid, what sections we see as most critical, and maybe pick those off in a priority order.
Yeah.
And then you could address the agenda that way in a bite-sized piece, because the 3 items we just talked about are gonna be pretty weighty items, and we may not be doing as much review next.
If you, those are all in your handbook
Oh, yeah.
that I passed out, so I don't know if you need it.
But you have them electronics, can we get them electronically, so maybe we
Yeah,
can
I can-
annotate them?
they're actually available electronically.
Oh, that's right, sorry.
I mean, I guess we could get them.
I guess we're all set.
Staff does enough work, we can go from there.
Yes. So you'll see my handwriting on my tablet for you now, little red marks and stuff. Cool. I guess I have a couple, or the 2 related ones. I think as I was walking in, Evan asked me how things are going. It's just interesting, and there's a lot going on in Lewiston, a lot of change, and a lot of some things. So a couple things. Originally, this position, this seat, we have a seat in Lewiston for an ad hoc member, a counselor, and then the public works director. And Mary Ann coming on and drinking from a fire hose for a while, we've been kind of metering out some of these committees to her. But I think with all that's going on now, we're gonna talk to her tomorrow, tag you're it. So you can probably see, I'll try to come some, but I think you're gonna see Mary Ann more. Also, I think this meeting, typically we, oftentimes we elect a new chair, and I think we kind of did do that this meeting, but I think that's something we probably want to also get on the next agenda, at the beginning of the next agenda, and figure out who the chair is. So if people want to feel like comfortable being nominated or feel comfortable doing it, it might be a good idea to just to have a chat with some other commissioners and so we kind of get that rolling. I'd like to continue. I really feel bad, but I think with what's going on, I won't be able to give it the attention for a while. So.
I guess my question would be, I guess this is something I did for, when I told people I was stepping on Australian planning board, made sort of a description of what they could expect, only because, so, you know, the interlocal might mention a chair, but
Doesn't say much.
it doesn't say much, right? So maybe if we're gonna do that,
Yeah.
I think have a vote next meeting, have a sort of a description or something.
Maybe sometime between now and then, Kevin and I can kind of pull it out. A lot of it's just, and I don't do a great job of it, but trying to go through Robert's rules and just.
You do a good job of it.
Yeah. Yeah.
Great even.
Keep going, Dan. Yeah, unfortunately, I wish you could. But it's just running through it. I think it's a lot easier here. You know, on Zoom, we kind of got, for a while, we were going to get, and then at the end, we're actually doing pretty good with that. But it's a lot easier in person, not talking over each other and stuff. So I think it's going great for the complex issues that we have. Yes, maybe we can pull out some items on what the chair does and prep for meetings and then. On everybody is. You got till next meeting, so. We'll have some more victims maybe at the next meeting too. And it's sad because I do like being on this commission. It's one of the most interesting things we do. So. Cool. I think that's it. Motion to adjourn.
So move.
Second?
Second.
All in favor?
Great to see everybody.
Yeah.
I know, right?